Good morning, everyone. My name is Rumbidzai. I'm the Data Protection Officer for Belvedere Medical Centre and Safe Life Medical Aid. So I would just like to take you through this training for data protection. I will start by giving you a brief background of the Cyber and Data Protection Act, which has led us here. So the Cyber and Data Protection Act, Chapter 12.07, was first enacted in December 2021 as a response to increasing concerns around the misuse of personal data and cyber threats. It put together key aspects of electronic transactions, cybersecurity, and data privacy under one legal framework. This act came as a response to a different number of aspects. We are talking of technological evolution. There is an increase in digital services and online platform. So this was a necessary act, right? So there was also an increase in abuse of personal information. Personal information has just become a gold mine for others, where there is data monetization, where your personal data is now a valuable commercial asset, right? So here we are saying you give out information without knowing what the information is being used for. You walk into one of those bigger supermarkets, right? They are telling you they are running competitions and they ask for your personal information. They are asking for your date of birth. They are asking for your ID numbers. They are asking for your phone numbers, and you give out this information, right? You do not sign. You don't know the purpose. To you, the purpose of this information is probably to enter a competition or win something, right? You are entering a company at their gates. They have a security personnel asking you for your date of birth, asking you for your ID number, asking you for your phone number. And some of this information that they are taking from you is not really relevant. For what do they need your date of birth for when it comes to security at the entrance, right? So because we don't know what data privacy is all about, we end up giving out this information. We do not have the information. We don't know how they're going to use this information, and we end up just giving it out. So I'm here to tell you what data privacy is all about and how you can protect your personal information. So I'll just start by defining the key terms in data. When we are speaking of data privacy, looking at Zimbabwe and the Cyber and Data Protection Act of Zimbabwe. So at the top of this act, we have the Data Protection Authority. Here we are talking of the regulator, which is POTRAS, the Postal and Telecommunications Regulatory Authority of Zimbabwe, right? This is the Data Protection Authority. And we also talk of data subjects. Data subjects here, we're just referring to a natural identifiable person. And who is the subject of data? We're saying this is the owner of the data that is being collected. At BMC here and Safe Life, we're talking of our patients, right, that we collect personal information from. We're talking of employees as well. They are data subjects. We're talking of the people that work for Safe Life, the people that work for Belvedere Medical Centre. We're just talking of you and me, our personal data, right? It also needs to be protected. Then we speak of the data controller. We cannot talk of the data subjects without talking about the data controller. The data controller in this case is the natural person or legal person who is licensable by the authority. So this is Belvedere Medical Centre. This is the controller, right? We're talking of the organization when you're talking about the data controller. Subject to Section 4 of the Cyber and Data Protection Act, we're saying a controller is any person who processes personal information with the intention to decide means, purpose, or outcome of the processing, to decide what personal data should be collected, to decide which individuals to collect the personal data from, and to obtain a commercial gain or other benefits from the processing of personal data. In this case, this is the processor. So it's Belvedere Medical Centre and Safe Life, we are data processors. Then we have joint controllers. Here we are just talking of the people that we work with, the people that also controls personal information, that we share the information with. We are talking of other medical aid societies. We are talking of other laboratories that we share information with. We are joint controllers with them. So We also have the data processor. The data processor refers to a natural person or legal person who processes data for and behalf or on behalf of the controller under the controller's instruction. So in this case, we are talking of the owners of those systems that we use. They are the processors. They are not controllers. Like Flexi, they process personal information on behalf of the controller. We are saying, in all this, the data processor, the data controller, the data subject, we are saying the controller shall be accountable for his or her representative, agent, or assignee data processor. So the controller is the one who is responsible for everything that happens to personal data. So in this case, every data that you share with your processors, with your agents, with your employees, as the controller, you are the one who is responsible for anything that happens to that personal data. Let's look at data processing agreements. So we're saying a data processing agreement is an agreement between a data controller and a data processor. So for us to make sure that we are safeguarding the information of our employees, we are safeguarding the information of our patients, we have to have a data processing agreements with our processor. Like I said, our processor in this case is those guys from Flexi Health. So we have to have a data processing agreements with them. And in these agreements, the agreements should lay out technical requirements for the controller and processors to follow when processing data. This includes setting terms for how data is stored, processed, protected, accessed, and used. So these processors should tell us how they protect the personal data that they are processing, that they store wherever they are, right? So now we look at the data protection officer. This is an individual appointed by the controller and is charged with ensuring an independent manner compliance with the obligations provided for in the Act. So that is me, the data protection officer. So now let's look at consent, right? Consent refers to any manifestation of specific, freely given, informed expression of will by which the data subject or his or her judicial or legally appointed representative accepts that his or her data be processed. So we're just saying consent should be written, it should be freely given, and it should be informed. Like when we are asking our clients for consent, they should know what they are consenting to. We just don't bundle up terms in those consent forms and just say agree without explaining what it is they are really agreeing to. So consent should be freely given. It doesn't need to be forced. Like you're saying, if you don't consent to this, you don't get this service. Now that's forced consent. So consent should be freely given and informed. We've been talking about data processing. All this is centered on data processing. We want to protect the data that we are processing. So what is data processing? Processing refers to any operation or set of operations which are performed upon data, whether or not by automatic means, such as obtaining records, obtaining, recording, or holding data, or carrying out any operation or set of operations on data. This includes organization, adaptation or alteration of the data, retrieval, consultation, or use of the data. So anything that you do to the data that you collect is what we call processing. What is personal information? On personal information, we are talking of the person's name, address, telephone numbers, the person's race or ethnic origin, the person's age, sex, sexual orientation, marital status or family status. We are talking about information about a person's healthcare history, including a physical or mental disability. This is what we call personal information. So there are special categories of data. There's data that is classified under the special categories of data. Data under this category includes genetic data, biometric data, or sensitive and healthy data. So I'm more concerned about this because this is the data that we work with. Here at Belvedere Medical Centre, we use biometrics, right, to collect personal information. And we also collect what they call sensitive data. This is health data. So it needs to be protected. it's under the special categories of data. Let's talk about the data breach. What is data breach? We are saying a data breach occurs when the data for which your company or organization is responsible suffers a security incident resulting in a breach of confidentiality, availability, or integrity. I think we will understand more of this when we go to the next sections of this presentation, right? So let's just look at approach to handling personal information. Processing personal information involves collecting, handling, storing, and using data about individuals in a way that complies with applicable privacy and data protection laws. Data protection laws mandates adherence to data protection principles. We'll talk about these principles as we go. With respect to the rights of the data subjects, we will also look at the rights of the data subjects in this presentation. Then compliance with all provisions of the Cyber and Data Protection Act, including its associated regulations. Right. So yeah, here I was just defining the key aspects of data protection: the data subjects, the data processor, the controllers, right? So now we are looking at the data protection principles. These principles are what you are expected to abide by when you're processing personal data. You have to stick to these principles, right? You have to be in line. So we have 7 data processing principles. We have lawfulness, fairness, and transparency. This is one principle. We have purpose limitation. We have data minimization. We have data accuracy. We have storage limitation. We have integrity and confidentiality, and we also have accountability. So I'll just look at these principles one by one so that we understand what these principles are all about, and we also introspect and see if the information that we are collecting here, we are abiding to these principles. And if there are any changes to be made, we make those changes. So the first principle is lawfulness, fairness, and transparency. So we are saying data should only be processed if there are lawful grounds for doing so. On lawful grounds, I will look at it at a later stage, but on lawful grounds here we're saying, do you have permission to process the data that you are processing? What lawful grounds are you processing that information on? Do you have consent? Right. So I will look at other lawful principles here. Is it fair to the data subject? So whenever you're processing information, you have to look at the data subject. Is what you are doing fair? Are you not stamping on the rights of the data subject? Is it also in a transparent manner understood by the data subject? Does the data subject understand why you are collecting that information and what you are using it for? We also look at purpose limitation. When data is processed, it should be specific, it should be specified, explicit, legitimate, right? So the data that you collect, you should only collect the data that is limited to the purpose that you are using it for. No other processing should be done after that. If you've collected information to help with a patient with treatment, you should only use that information for treatment. If there are any other uses that you intend to use this information for, you should let the patient know. You don't collect personal information from patients to treat them. Then later you start sending them advertisement messages without their consent. It's not allowed. So on purpose limitation, the information that you collect should only be used for the purpose it has been collected for. And that has been explained to the client, to the data subject, right? Then there's also the principle of data minimization. On data minimization, we're saying personal data should be adequate, relevant, limited to what is necessary in related to the purpose for which it is processed, right? You don't collect the information that you don't need. When you want to, we are looking at patients here. Do we need the information on their income? No, we do not. So we don't collect such information. We should try to minimize the information that you collect, so that, because if you collect too much information, there's a bigger risk of data breaches. So you just limit the data that you collect to the purpose that you want to collect it for. It should only be relevant to the purpose that you're collecting it for. You don't collect too much information from from our data subject. Then we have data accuracy. The main element of accuracy includes correctness. Personal data must be factually correct. Inaccurate or misleading data can lead to errors that may harm the individual. There should be completeness. The data should be complete and not missing important details necessary for its intended use. It should be up to date as well. Should make sure that we update the personal information that we have. Some individuals may change their surnames, some may change their names, so we should always ensure that the information that we have is up to date, and there should be room for rectification. Data subjects or individuals whose data is being processed have the right to request corrections if their data is inaccurate or outdated. Right. Then we also look for storage limitation. The main components of storage limitation are retention periods. Data controller must define and adhere to retention periods, ensuring that personal data is only stored for the length of time necessary to fulfill the purpose of which it was collected. Right? So you don't need to store people's data for longer periods of time. You just keep the data for the periods that are useful to what you need the information for, right? There should be room for deletion or anonymization. Once the retention period expires or the data is no longer required, banks or health institutions must either delete the data securely or anonymize it so that it can no longer be linked to an individual. So here we are saying you should have policies. You should have data retention policies and data deletion policies, where you say after this period we delete all the information that we have, and how you delete the information should also be specified. Right. So now we look at confidentiality. This is just a confidentiality example. Imagine a healthcare organization that uses an electronic health record system to store patients' data. The integrity of this data is paramount, as it must accurately reflect each patient's medical history, treatments, and medication. So to ensure integrity, the organization implements strict access control, allowing only authorized personnel such as doctors and nurses to update or modify patient records. So confidentiality, on the other hand, is maintained by encrypting patients' data both in transit and at rest. The organization trains its staff on the importance of confidentiality, emphasizing that patient information should only be shared with those who have a legitimate need to know. For example, a nurse might need to discuss a patient's condition with a physician, but the patient details should never be shared with administrative staff who are not directly involved in patient care. So we're saying on confidentiality, we should ensure that patient health data is only accessible to those that use that information, that are useful, like the nurses and the doctors. Then we talk of accountability. So whenever we talk of accountability in data protection, we are talking of the controller. The data controllers should demonstrate compliance with the Cyber and Data Protection Act to both data subjects and the Data Protection Authority. Right? How do you demonstrate accountability? By following the Cyber and Data Protection Act, by having a record of processing activity. As the controller, I will talk about this maybe at a later date, where you should have a record of processing activities. You should do data impact assessments. This I will talk about maybe at a later stage. Questions?
Okay, you rightfully said the controller in this respect is a BMC for our institution. Let's say BMC has got agents who collect data, like Save Life agents who collect data. And some of the information maybe leaks. The client does not sue the agent, will sue BMC.
Exactly.
This is how BMC remains the controller, and the accountability lies on the Okay.
You are correct. So we are
Okay.
saying accountability lies on the controller.
Okay.
Any breaches to the personal information, any misuse of personal information, all comes back to the controller. The controller is liable for everything that happens, which is why the controller should ensure that they abide by the data processing principles.
Okay.
Yes.
Then you also said the controller is got to come up
Mhm.
with a time frame where they keep, or maybe when they decide to delete, or yes.
Yes.
So do you currently have?
At the moment, we are just guided by the Health Professions Act, where we are expected to keep health record for 10 years. Like I've said before, lawfulness is part of our data processing principles. So now we're looking at a lawful basis for processing personal data, right? So what is lawful basis? The first data protection principle of lawfulness, fairness, and transparency, right? It says we should have a lawful basis for processing personal information. So each processing activity that you do needs to have a lawful basis. So processing includes collecting, using, or sharing personal information. So in order for you to do this, you should have a lawful basis. So what to think about first? Consent is at the top. Should you consider it first? In deciding whether or not to use consent, answer the following. So we are saying there are other lawful bases other than consent. Consent, we are saying, is at the top, but consent you should not be considered first. You should know, after consent, do you have any other lawful basis of processing personal data? Because you know what, consent can be withdrawn at any given time. So you should have other lawful basis when processing personal information. You need to think, do you definitely need the data, whether or not you get the consent? Do you need the data? Are you desperate for the data with or without the person's consent? Will you try and force the consent? We said when consent is forced, it's not valid. Will someone be penalized if they don't give consent? Penalizing someone for not giving consent is also known as a form of forced consent. If someone withdraws consent, would you have a problem or stop using the data? If the answer to any of these above four questions, then consent is not the best lawful basis for you, right? So pick the correct lawful basis to process personal data. Identify the purpose of processing activity. For example, we do this to comply with anti-money laundering laws. We use the customer's address to send them products they've bought under our sales contract. Other rules apply, e.g. sensitivity of the data. Other rights that apply to give and withdraw consent. So we are saying other legal basis that you can use. So we have consent, we have contractual obligations, we have legal obligations, we have vital interests, we have public interests, we have legitimate interests. Whether the data subject has made the information public, this information that has been made public you can use. Then when conducting scientific researches. So what is valid consent? We are saying valid consent is freely given, it's specific, is informed, unambiguous, and confirmed in writing. So consent should be confirmed in writing. You don't get consent by word of mouth, because the person can wake up later and say, no, I did not agree to this. So consent should be confirmed in writing. There are things that no matter what, you need consent. You cannot use any other lawful basis other than consent in these cases. We are saying when processing sensitive data, like in our case, we cannot use any other lawful basis, because we collect sensitive data, which is patient's health data. So for that, we need their consent. When processing of non-sensitive data, you can use other legal basis if they apply, right? When processing genetic, biometric, and healthy data, you need consent. What to include in a consent form: the controller's identity and business address, the purpose of each of the processing activity for which consent is sought, what type of data to be collected and used. Data subjects must be made aware of the right to withdraw consent. They should know that they have the right to withdraw consent. Where they don't want you to process their data, they can withdraw consent. And also, if the automated decisions are going to be made, um, you should let the clients know. When you make automated decisions, like these are decisions that are made maybe by the automatically. This can include maybe when you are using maybe an online platform to recruit, or you're using a software for recruitment purposes. So if consent relates to transfers, the subject must know the privacy safeguards and risks to the third party country. If you are transferring personal information to other countries, the data subjects must know. As the data subject, if you don't act, it means you've consented. No, there should be action. They should consent. Okay, so I'll just skip on consent and we look at the rights of data subjects. The right of data subjects, we're saying the data subjects have rights to be informed, right to give and withdraw consent, right to access information, right to object, right to rectification, right to deletion, right related to automated decision making, and right to complain. You should inform the data subjects about what information is being collected, why is the information being collected, how the information will be used, where the information will be stored, and the data subject must fully understand. They have right to give and withdraw consent. Like I have said before, whenever consent is given, it can be withdrawn. Withdrawing consent must be easy and free of charge. Consent is given in writing, but it can be withdrawn by word of mouth. It can be withdrawn through phone calls. A person can just say, you know what, I'm forbidding you from processing my personal information. So where it is difficult for the controller to continue processing after consent is withdrawn, then the controller must not rely on that in the first place. Remember what constitutes a valid consent. Right. So there's also the data subject has the right to access information. We are saying data subjects have right to access information that is held by the controller. The controller must put in place mechanisms that make it easy for data subjects to access their information. So if a data subject comes here and say, I want to know all the personal information that you have on me, you should be in a position to give them. It's their right to access that information. If an employee goes to the HR office and say, I want to know all the information that you have about me, it's their right. They should be able to access that information. There's also the right to object processing. After accessing their information, data subjects may choose to exercise their right to objection. A data controller may raise an objection to part of the processing activity of the controller. The right may be limited by operation of law. There's also the right to collection. We're saying a data subject has a right to have their information corrected. So whatever systems that you have, you should be able to edit and correct personal information. If a person comes in and say, the information that you have on me is wrong, they have the right to have it corrected. There's also the right to be deleted, the right to be forgotten. We're saying this is also a right to be forgotten. This is when the data subjects ask the controller to delete them from their database. A person can just say, I want you to delete every information that you have on me. Though this is subject to limitations exposed by the law. Like in our situation here, we are expected to keep people's personal health data for 10 years. So if they come and say they want the data to be deleted, we are not able to do that. Right to related automated decision making. Data subjects must not be subject solely to automated decision making. There must be a human interface. This is the start of the law that regulates artificial intelligence. So we are saying, let's say you're looking for a job at Belvedere Medical Centre. You've been asked to maybe use our HR system to send your application form. You're saying you have the right to ask for a human decision. You're saying maybe the automated decision is biased, or it's not picking the information that you are using. So you have the right to request, no, I don't want this automated decision making. You have the right to complain. A data subject have a right to complain to the data controller if their information is not properly being handled. They also have the right to control to the Data Protection Authority, which is POTRAS. So this marks the end of this session. Today we've covered important definitions, we've covered data processing principles, we've covered data subject rights. In our next session, we'll be looking at the functions of the Data Protection Authority. We'll be looking at the functions of the data controller, the data protection officer. It is our duty as Belvedere Medical Centre and Safe Life to ensure that we respect and protect the privacy of our clients, the privacy of our employees. So we take this quite seriously. Thank you.